The next podcast is a bit of a departure from our usual pattern. You're going to see a program recorded at the Attorneys Resource Conference. In this session, I joined forces with seasoned attorney Sam Davis, Esquire, to unravel the story behind a catastrophic birth injury case. The next podcast is a bit of a departure from our usual pattern. You're going to see a program recorded at the Attorneys Resource Conference. In this session, I joined forces with seasoned attorney Sam Davis, Esquire, to unravel the story behind a catastrophic birth injury case.
Good morning, everybody. I'm going to introduce our next speakers here. Session 5, 1 minute's count. Samuel Davis, Esquire, founding partner of Davis, Saperstein, and Solomon, P.C. Samuel Davis, Esquire, is admitted to the New Jersey Bar, the District of Columbia Bar, the Federal Bar, and United States Supreme Court Bar. Sam Davis has also been certified by the Supreme Court of the State of New Jersey as a certified civil trial attorney. As the original founding partner of Davis, Saperstein, and Solomon, P.C., he has represented thousands of clients who have suffered personal injuries. He settled a burn personal injury case in 2022, which represented the largest personal injury settlement in New Jersey that year. Also is Pat Iyer, MSN, RN, LNCC. She established a highly successful independent legal nurse consultant business in Flemington, New Jersey in 1989. She testified as an expert witness for 25 years as a liability expert for medical surgical cases and expert fact witness. After growing this multi-million-dollar business, Pat sold the company. When Sam asked Pat for help with this case, she returned to the legal nurse consulting world and now works with personal injury and medical malpractice attorneys. She is a business coach for LNCs and creates books, courses, and online training to help LNCs make more money, get more clients, and avoid expensive mistakes. She was a president of the American Association of Legal Nurse Consultants and also served on its board for 5 years. She is a legal nurse consultant certified. Welcome.
Thank you. When Eddie and Estefania walked
Hold on 1 second. I'm sorry. That is so rude when a lawyer is giving an opening statement to interrupt. And a lot of times it's very risky. It's risky to do that. But to get the flavor of the Sam and Pat, I thought I would start off with an interruption in her opening for the following message. How the hell did you get me to Detroit? Okay, I'm going to answer that. I'm going to answer that question, and it has to do with this. 30 years ago, like this month, 30 years ago, Pat and I started working on a case which, like a lot of my cases particularly that I bring Pat into, turned out to be one of these spectacularly well-published, it hit the press. It was the first time that Madison Square Garden had ever been held accountable for over-serving a patron who then went out and killed one of my clients and put the mother in a coma. So over the last 30 years, I brought Pat into every one of my mega cases. And so, I can tell you that my 7- and 8-figure cases all have her stamp on them. And it's for that reason that I wanted to tell you, this is not a plug for Pat, okay? Because I don't know, if you have enough work to do without, but I just want to tell you how excellent she is and how I have come to rely on an LNC to be my other half in my major litigated cases. And just to get an idea of who, we usually, when we're trying a case, we get a list of the jury veneer. We want to know who's going to be sitting in the box, who we have the choices of. It's kind of like when you're playing blackjack, you want to know what's in the deck. Because if you use all your challenges and all you have left is engineers and mathematicians, plaintiffs don't want those, you're out of luck. So could I just see how many plaintiff's lawyers are here today? 0 plaintiff's lawyers. Well, okay, I guess I'm representing the plaintiff's bar then. How many defense lawyers? Okay, we're even. How many people that are not LNCs, like representing healthcare institutions, hospitals? Okay. So in any event, this is really an LNC event, and Pat and I are going to be talking about this really, really tragic case. And this comes at a time where my life as a lawyer is totally rearranged. You know what 2 letters I'm talking about. And if my life is rearranged as a lawyer when I approach cases, your life is too. And so as we are going through this, I reserve the right
To interrupt.
this incredible woman who keeps all my stuff together on these years-long crusades, and this tragic case is perhaps the most recent one that Pat and I worked on. So, thank you, Pat.
May I proceed?
Please.
All right. When Eddie and Estefania walked into a hospital within sight of Manhattan on July 20th, 2020, they were excited. They were having their first baby. They were already informed this was going to be a girl. They had named her Emma, and they were ready to get this done. 5 months later, Estefania was wheeled out of the hospital with an anoxic brain injury and spent the next 4 years in a rehab facility and was moved only after this case was settled. We're going to share with you today what happened in that delivery room, and you'll first get in this first video clip a sense of who Eddie and Estefania are, their daughter Emma, and their mother Luz, who was Estefania's mother.
If she's going to be full Colombia, today's Colombian Independence Day.
So when I had Emma, sorry, me and Estefania talked. She knew what I went through not having a father, and I told her, I'm gonna be the best father that I could be. Emma was 5 pounds, 11 ounces. It's a joy. Having Emma in my life is just a blessing. It just gives me that extra strength to wake up every morning. It's very tough, like not being with her and like turning off the lights and not knowing she's not next to me. It's really something that's very painful that, I used to look at Emma and I look at the side of her bed and knowing that she's not there just breaks me down every night.
We're going to share with you today some of the key highlights of this complex case that took approximately 4 years from start to finish to be able to settle. There are many nuances in this case, and you'll get the highlights. Emma was born to Estefania. You see the before and the after. The after picture is her in ICU shortly after delivery. This is a picture that was taken in the delivery room This is the actual room where all of these tragic events unfolded. There are a number of players that we uncovered in the process of litigating this case, working it up. I as the legal nurse consultant, Sam as the attorney, and you will meet some of these as we talk about the facts of this case. Selvia Zaklama is an Egyptian-born anesthesiologist who was the defendant in this case. She was in her 60s. She was a difficult woman. There were many complaints about her behavior. She was written up 38 times in an 18-month period for behavioral issues. The woman next to her is Francine Hyman, who is the obstetrician. Below her is Dr. Patel, who was the third-year resident, and he had some significant information to share in his deposition about what went on in that delivery room. Thank you. We have Amanda Salerno, I appreciate that, who is the nurse on the top row there. She was out of nursing school approximately 10 months at the time of this incident. She had never been involved in a code in a delivery room. She had never opened the crash card after she went through orientation 10 months before. Below her, Rita Penanueva, an experienced nurse who was also in the delivery room at the time. And then Dr. Sabri, who came from the ICU for the code and was the first person to do compressions. That becomes significant as we go through the timeline of events. Using the anesthesia record, the testimony of individuals, the nurse's notes, and the operative report, we were able to piece together what happened during a critical period in Estefania's life. All of the action that we're talking about took place in approximately 40 minutes. It is difficult, because of the poor quality of the handwritten anesthesia record, to be able to establish what happened at what time. We know from the anesthesia record that Estefania was brought in for an emergency C-section at 7:30 in the evening. It was at the change of shift. Amanda Salerno was her nurse who was assigned to her. Estefania was not progressing. Labor was arrested. It was obvious that she needed an emergency C-section. So Dr. Zaklama, who had been monitoring this patient's epidural and maintaining her anesthesia through the epidural, gave her a 15 cc injection of bupivacaine and fentanyl all at once at 7:30 as Estefania was being settled into the delivery room. You can see from the diagram and the names of the people that Dr. Zaklama is at the head. She is the bright red figure, and then she's surrounded by the purple, who is Dr. Hyman, the two residents. There were initially two residents in the room. And then we also had Rita Penanueva and Amanda Salerno, who were in the room, as well as in the yellow, a surgical technician. The delivery room was set up with the bassinet ready to receive the baby when she was born. Outside this room, in the hallway, is the crash cart somewhere down the hall, and there was a telephone that was immediately outside the door that was dedicated to calling a code. All you had to do was pick it up, dial 222, and you were connected immediately to the operator of the hospital. In the initial medical record, there were no vital signs recorded at 7:30, and then Dr. Zaklama was recording approximately every 5 to 10 minutes. She was taking vital signs and recording them. At 7:45, Dr. Zaklama noted that the patient's blood pressure had dropped, her pulse was dropping, so she's decided to give an injection of ephedrine to try to boost the patient's blood pressure. It was a 10 milligram dose. We had an expert in the case who said that was inadequate response, too small of a dose. And no one in the room knew that there was a problem. No one was aware that this patient's blood pressure was dropping except for Dr. Saklama. The rest of the team was focused on getting the patient ready so that they could do the incision and the C-section. At 7:49, Dr. Saklama gave another dose of fentanyl. No vital signs were recorded. We don't know what the patient's status was. There was no documentation that corresponded to that time. And shortly after that, we believe the alarm went off. Because of a blood pressure of 90/50, it was flashing, it should have been making a noise. No one in the room heard it. No one who was deposed exhaustively. Did you see the monitor alarm? Did you hear anything? Were you aware of a problem? No one in the room was aware of it except for Dr. Saklama. We now have the baby about ready to be delivered. She's out of the incision. The team is ready there to take her away into the nursery. And again, we're missing vital signs. We don't know what the blood pressure and pulse were at that point. At 8 o'clock, we have a reading of a pulse of 62, a blood pressure of 70/30. No one in the room was aware of this except for Dr. Saklama. At 8:01, Dr. Patel, who is one of the residents in the room, the other resident who turned out to be pregnant, went into the bathroom and vomited and stayed out for the rest of the surgery. She was no longer in the room. So there was one resident who was in the dark brown. He notices that the uterus is atonic, doesn't have normal muscle tone. It's dusky, and it's not bleeding the way that it should be in the process of having the cesarean section. So Dr. Saklama says, Dr. Patel says to Dr. Saklama, "Is everything okay?" And Dr. Saklama says, "I've lost the airway. She stopped breathing." Now, there was no endotracheal airway in place. I lost the airway, we later determined meant she was saying she wasn't breathing, although she did not give Sam a very clear answer in response to his questions about this. We believe that the monitor was still alarming, and the patient's heart had stopped. Dr. Saklama asked for help from Nurse Salerno. She's starting now to ask for epinephrine and atropine. And Nurse Salerno has not been in a code before, doesn't know where those medications are located. Dr. Saklama is saying, well, look in the anesthesia cart. Nurse Salerno is fumbling through the cart. She's never been involved with the anesthesia cart before. She can't find it. She begins to ask herself and Saklama, what's going on? What's occurring here? She continues to look for the medications at 8:02. The patient still has no pulse and no blood pressure. The alarm is still going on, and she's still looking for medication, and she decides, oh, wait a minute, I can go out and to get the crash cart. I know that those drugs are in the crash cart. That was something that I learned during my orientation. Haven't seen the crash cart or touched it since, but I do remember that part. So she goes out into the hallway and gets the crash cart and brings it into the room. While she is out of the room, the alarm is continuing to sound, we believe. And you'll hear me say we believe because you'll find out why we believe it and we can't verify it. She opens up the crash cart, she gets the epinephrine and atropine, and then she hands it to Dr. Saklama. It is a Luer jet. It's got two components that you have to screw together. She has no idea how to put it together. Dr. Saklama is very irritated, very upset with her, as you will hear her testimony. And they assemble the medication,
and start the medication, the resuscitation drugs at that point, at 8:08. Rita Penanueva, the very experienced nurse with 30 years of experience, decides at that moment that her priority is to take the blood from the cord gases down to the respiratory therapy department. She knows that Amanda is in the room by herself, and Rita leaves. And by the time Rita comes back, they're in the midst of the code, and Rita stays out of the room because there's already too many people in the room, according to her testimony, so she feels she can stand out in the hallway, leaving Amanda in the room with the code team, who eventually come. We now have Dr. Saklama realizing she is in over her head. She is in trouble. She decides she's no longer managing the situation, so she calls a code. She says to Nurse Salerno, call a code. Nurse Salerno walks past the code phone, which is in the hallway, down to the nurse's station and tells the unit secretary, call the code team. Now, she testified she didn't use the phone because she wasn't sure it worked, and she knew if she talked to a human, she would get a response. We lost a little bit of time in that process. Dr. Saklama now decides it's time to intubate the patient, and does so. She fraudulently charged that she's got a blood pressure of 80/42. There was no blood pressure at that point. There's nobody doing compressions, and now the patient does have an airway in place. Then the code team arrives, and they start compressions for the first time, 11 minutes after the cardiac arrest at 8:12. The alarm is continuing to go on. Sodium bicarb is given. Dr. Patel continues compressions with Dr. Sabre. They are working together as a team, and we get epinephrine into her. At 8:14, the patient gets sodium bicarb. We're now 13 minutes into this, and at 14 minutes, she has the resumption of vital signs. She's got a pulse. She's got a blood pressure. She is now at the point that they can stop this cardiac arrest and focus on getting this patient transported to ICU. She gets a dose of Lasix. She is put on, she's kept on the delivery room stretcher, and she is then transported into ICU, where she spends most of the next 5 months. First on a ventilator, gradually being weaned from the ventilator, and then ultimately transferred to a rehab facility. When Sam contacted me about this case, it was about 6 months after the events that happened. It was February of 2021 that he contacted me and asked for some assistance with this case. And the two of us worked together to bring justice for Estefania. The mystery is what happened in the delivery room. What caused this patient to have an arrest? That was the task that we were faced with. Could we untangle the poor documentation, and at that time had no depositions, had no policies, had no discovery that was giving us much in the way of answers. All we had was a poorly handwritten delivery record, an anesthesia record, notes that the nurse wrote after the fact, the delivery summary from Dr. Hyman. Those were the only 3 pieces, and a code sheet that was filled out by Nurse Salerno the day after the code. Why did nobody in that room, and Sam asked each of those defendants, each of those fact witnesses, did you hear the monitor? Did you see the monitor flashing? Why was nobody aware of this? Why was this a secret that this patient was deteriorating until it was inescapable that Dr. Saklama had to tell other people in the room that there was an emergency? And then what were the events that led up to this? this didn't happen in a vacuum, and Sam will talk more about this hospital, the priorities that this hospital had for patient care, or lack thereof priorities, and then what happened after this event in the process of looking at this catastrophic event. How well did the hospital's risk management and investigation process go to uncover what went on in that delivery room? One of the big issues then was what caused the arrest. We had experts who came in and offered their theories about what happened. Defense attorney hired experts who came in and offered their theories about what happened. Could we, and this was part of what I did, look at what are the causes, the probable causes. At that point, we didn't know what the defense experts were going to say, so we tried to anticipate. Are they going to say an allergic reaction, an amniotic fluid embolism? Are they going to say that it was pulmonary edema, pulmonary embolus? What are they going to come up with to explain why this woman, normal, healthy woman, had a cardiac arrest? And how long is she going to live? She was 27 years old at this time. Defense position would be, let's try to make sure that her life expectancy is as small as possible. Plaintiff perspective is, let's see how long we think she can live. How long can we expect her to live? Who knows? None of us know what our life expectancy is, but that's an important calculation when you look at the damages and how much money do you need to be able to take care of this unfortunate woman for the rest of her life. I worked with Sam to anticipate his needs and identify the timelines and chronologies that we needed to put this case together. First of all, I focused on, let's transcribe this anesthesia record, put together the vital signs that were from this poorly written, handwritten anesthesia record. It would have been lovely if this was an electronic record. We didn't have that. We had, and for those of you who've been in nursing for a while, we had upside down carrots, and they were sort of on the line, but not really on the line. Was it 15 minutes? Was it 30 minutes? Hard to interpret, and much of it was incomplete. I did a timeline of the epidural, thinking that one of our theories was that the epidural was associated with the arrest and the medication that was given in the epidural. It had to be reinserted at a point when she was in the labor and delivery room, so that we looked at when it was reinserted and could it have been misplaced at that time. What medications were given to her? We had medications that were on the anesthesia record. We were able to get the records from the Pyxis, from the anesthesia cart. We were able to look at the timing of those medications to try to put it together with what Dr. Saklama had recorded on her record. And then, how did this hospital allow this doctor with all of these behavioral issues onto the staff? Now, you may know that the hospital has to contact the National Practitioner Data Bank to find out if anyone who's applying for privileges has been sued before. Well, there were some redacted portions of her record. And we could tell from the redactions that there was at least one, if not two, reportings of similar cases. We had no idea what was under that redacted section, but if you search for the name of the doctor, you find information about prior lawsuits and also prior bad behavior. One bad behavior that came up in our investigation of her was that she was driving her black Mercedes one night and hit a pregnant woman who was a pedestrian with her car. She scooped this woman up, put her in her car, took her to the hospital, and said, "Look at who I found on the street. I'm bringing her in so that we can do surgery on her and fix her injuries." Never told them that she was the driver. There was unfortunately somebody who was a witness who saw the incident, and then Dr. Saklama got exposed and had some charges against her, which were ultimately dropped. Did the hospital investigate that? Did they think that possibly they should look into the character of this person? They checked all the boxes, they did all the forms, they got all of the evaluations, and she was credentialed. I also did a timeline of what happened immediately after the code. What were her conditions? What were her symptoms? When she was in ICU, did she display symptoms that would be consistent with pulmonary edema or amniotic fluid embolism or an allergic reaction? Anticipating, again, where was the defense going to go? And I also did an extensive 5-month step-by-step Excel spreadsheet showing her reactions. One of the ways that you can look at this from a damages perspective, if you're on the defense side, is to say, well, she was on a ventilator in ICU, she wasn't aware of anything, she wasn't responding. Oh no, that wasn't true. Eddie brought a video of Emma and showed it to Estefania, and Estefania cried when she heard her baby crying. Estefania grimaced. She reacted to painful stimuli. She would look and beam and get very happy when Eddie came into ICU to visit her. She responded and she showed emotions throughout those 5 months and then in the subsequent next 3 years. Another piece of what we looked at was, now it's time to take depositions. What do we want to get out of each of the people that Sam is going to depose? What are some of the strategy points we should cover? What are some of the questions that he should cover? And once we have those deposition transcripts, then I summarize them, and we use those throughout the case for briefs and to prepare for other depositions. There were a total of 22. We also looked at each of the expected and, in turn, delivered theories of the defense. This patient was allergic to pineapple and asparagus. Therefore, she must have been allergic to Lasix, and therefore her allergy to Lasix must have caused an anaphylactic reaction. That was one of their theories. Some of their experts had more than one theory. They threw in 2 or 3 to see what might stick. An amniotic fluid embolism. In approximately 85% of all people who experience an amniotic fluid embolism, which is a reaction to the amniotic fluid that gets into the bloodstream, in about 85% people have DIC, disseminating intravascular coagulopathy. DIC is much easier to say. They had to argue she had AFE and she had an atypical form of AFE because she did not bleed out of any of her ports at all. So it had to be atypical. It must have been AFE. And AFE is very difficult to diagnose with a test, to say, all right, this is what you got. But she didn't have any symptoms of AFE. She had pulmonary edema. Well, we do know, and Sam will talk about this a little bit later, we do know that the head of anesthesia asked the anesthesiologist when the patient was in ICU, the day after, be sure you go through your anesthesia record and make sure it's complete. So Dr. Saklama took that handwritten anesthesia record and added the word questionable pulmonary edema, trying to cover her bases. She did testify she saw frothy fluid. However, the patient's lungs were clear on x-ray. And you don't go from a 95 O2 sat and then pulmonary edema and then to a 95 O2 sat without any lowering in your O2 sat levels between. We got a lot of experts involved in this case to look at the causation and to look at the damages. And I worked with the experts to make sure that they understood the case, they had the records that they needed. We reviewed their reports. We made sure that they were clear on their opinions and their reports were written appropriately. And we brought in Chris Mew, who many of you know is a legal nurse consultant who did a Rule 1006 report for us to summarize this long period of hospitalization and the subsequent 4 years in the nursing home or in the rehab center. As we went through this case, we had the opportunity to ask the defense for discovery, so we were probing for policies on things like chain of command, crash cards, code sheets. There was an audit trail that was done, and it was interpreted by Michelle Gonsman, who is a legal nurse consultant, who found the most fascinating things in that audit trail that directly contradicted some of the testimony of the people who were involved in the investigation. Sam named the risk manager as a defendant and asked for punitive damages, and he will go through with you why he took that route. We asked for requests for admissions to verify some of the facts. There were interrogatories. There were also verge reports, which are the incident reports. I mentioned 38 complaints against this doctor in 18 months. We knew the date of the report. We knew the author of the report, but they covered up the middle column of this table that would explain why the doctor was written up by so many people so many times. However, some of the witnesses testified about her behavior, including the time that Amanda Salerno asked her to do an epidural on a patient who was delivering a stillborn and was very uncomfortable. And Dr. Saklama's response was, "I don't do epidurals for dead babies." We got that in testimony. That was very likely one of the verge reports. In the state of New Jersey, this was considered to be pure, protected, not discoverable. Sam did his best by going for the judge to say, "I want those verge reports." No, you're not getting them. But we had other testimony that described how the director of maternal child health went to the director of anesthesia one day and said, "I want this doctor taken off of my unit. She's upsetting my patients. She's upsetting the nurses." After I saw that testimony, I said to Sam, "You know, she had guts to do that." She was acting as an advocate for her nurses and her patients. And the director of anesthesia reassigned Dr. Saklama that day, but the next day she's back on the unit. And then there were briefs to the judge for various points in the legal maneuvering that I helped Sam in terms of writing. There were 2 mediations on this case. Sam will go into more detail on the coverage issues for this particular hospital. How much insurance money was available? How many other people who are catastrophically injured in this hospital were fighting for the same insurance money? A factor that influenced part of the settlement discussions. And in the process of getting the material ready for mediation, Sam bought a vital sign monitor of the same one that was used in the delivery room, which he brought into the mediation. We put together extensive PowerPoint slides to explain to the mediator what this case was about. The attempts to mediate this case were unsuccessful in those initial 2 attempts. And then I also prepared a timeline of the delivery and additional slides which went into the mediation deck. So now Sam will take over and share with you his perspective on this.
I'm going to keep you up here at the turret, okay? Because I'm going to step over here and this case represents a spectacular failure of the medical system, because that anesthesiologist never should have been allowed to practice, of the laws of our state, because it had something called the Patient Safety Act. If you can imagine that there is such a piece of legislation that under the veneer of protecting peer review allows a practitioner who has had complaints, serious complaints, to be quashed, to be kept under wraps, starting from the process of credentialing, which we showed was a rubber stamp event where the executive committee and the credentialing committee would meet, once a week or once every 2 weeks, and on this list there'd be 18 or 20 doctors that they would credential or re-credential. After fighting vigorously to get this doctor's personnel file, the hospital said, hey, we don't have a personnel file. There is no personnel file. Check the credentialing file. The credentialing file was empty, or at least it was empty when we went to look at it. So, starting at the very beginning, when they gave me the first batch of records, and the batch of records was this thick, and that was wonderful. Like, boy, they really gave me the records pretty quickly. Well, actually, it was the family that went to pick up the records. And the anesthesia records were missing. And I knew then what I was in for. I filed suit that week and started on a course that was really extraordinary. I mean, I can't remember, with the exception of maybe a mass tort or in tobacco, or in some pharma litigation where you take 22 depositions. But then again, the defense tactics were, they took advantage of everything they could in the way of the legislation, which I just described. Judges don't like to be reversed. And they don't like to be reversed, and plaintiffs' lawyers, man, I've got a woman who's languishing in a skilled nurse. It's actually not it's not a SNF. It's a rehab facility, and they let me know 3 months in that we can't keep your patient here. This is perhaps one of the craziest stories you will ever hear. We can't keep your patient in. This is Kessler. This is a pretty well-known. You folks are familiar with Kessler out here in in Michigan? They out here? So the point is, we had to try to keep our plaintiff alive. I mean, she deserved to live through this. And as Pat pointed out, you can deny it all you want on the papers, but when they saw, and we did a lot of videoing in the patient's room, when you saw her not just tracking, but responding to her daughter's presence, you know that argument was over. In any event, so the Kessler misadventure went like this. She's there. Kessler is doing everything they can to kick her out. They're calling the family in for meetings. They're putting all kinds of pressure on her. And plus, their tab is running up by, since there's no carrier managed care here, the tab, they were charging her $5,000 a day to be there. And when we went back to review the Kessler charts and the Kessler bills, they were taking this woman who was trached, and they were charging her for physical therapy, occupational therapy, twice a day for like 45-minute sessions, when there is no way that they could give her speech therapy. That can't happen. So about a year into her Kessler stay, they're transporting her from her bed to get physical therapy when what happens? They drop her out of the Hoyer lift. They drop her on her head. So they take the patient who had, we believe, a significant loss of consciousness. They take this brain-injured patient, they bring her to Hackensack University Medical Center, and Hackensack does an examination, and they basically say, hey, there's no fractures of her skull. They put her back into an ambulance to take her back to Kessler, and she starts seizing as soon as she gets into the ambulance. They bring her back in. They find that she has a brain bleed. They keep her in there. Of course, you know, I tell you this because I think you all understand how critical it is. If you don't have a living plaintiff, the defense has won the case on so many different levels, both on damages, on the jury appeal. They've won the case. And what happened when we went back to, she was discharged, what happened when we went back to Kessler? They had her belongings in a garbage bag, and they said, hey, she's been discharged. Somebody else's responsibility. Well, you know, really, all it took was one call to the head of Kessler. And I sent him, there was an Inside Edition piece. I think some of the video footage you saw of the family was from an Inside Edition piece. And I said, now think about what a you-know-what storm you're going to start, because that will be on the front page of the Daily News tomorrow. You take her back today. Don't you dare put the family through any more of this horror story. So, you know, we actually, using another set of nurses, we actually kept her as against the will of Kessler. We kept her there for 4 years until we were able to resolve the case and get her to an appropriate facility. I want to tell you about something really important that you all need to understand, and I think it is somewhat foreign to what the nuts and bolts and the daily rhythms of being an LNC. And that is that when experts battle, when you have, I mean, we had 4 or 5 experts, including the Virginia Apgar professor of medicine at Columbia University, who was going to talk about these AFEs. And one of the things that about AFE, has everyone here handled an AFE case? Could I see the hands of anybody who's handled an AFE case? Well, there's 2 of you. And you know, that's kind of surprising because AFE cases, there's no doctors who have actually, or there's a handful of doctors who've actually treated an AFE case because they're usually dead. But in any event, battle of experts. The battle of experts, the tie clearly goes to the defendant. If that's what you're doing, if you're going to put numbers and opinions about what this was, if you're going to do that, plaintiff loses. Not necessarily because the defense has more seasoned experts, and in this case, you know, this was like a clear-cut AFE. By the way, AFE is also known as the get out of jail free card. Because, yes, we were showing all kinds of bad stuff that the hospital did, but their shit don't happen defense, which is, that's a powerful defense. Like, forgive all these people for some of the minor things that went wrong, but it wouldn't have made a difference because, hey, it's not AFE, it's something else, or it's AFE, non-typical AFE, so that didn't matter what else happened. So my point is that you need to create a framework that will let the jury, in addition to having humanized the plaintiff and the plaintiff's family will give them a theme. It will explain in advance where all of these pieces are going to fit. And here, this was our opening theme. They had to admit that this was a serious preventable adverse event. And we kept going back and harping on the preventable. And the deeper we dug into the preventable, we saw so many systemic failures that it was mind-boggling. And at a point in time, we actually had to trim away. We had to trim back some of what we thought were really the most critical reasons that this happened. Now, I told you about this news special edition news broadcast. It's like a 3 or 4 minute piece. And as a result of that having been, Inside Edition, that having been broadcast, I started getting phone calls. I was getting phone calls from nurses who'd been fired from there, from all kinds of people. But the most important one that I got was from the nurse, maternal fetal nurse educator. Okay, well, boy, now I have my peek behind the curtain. And what she had to say led me on the most incredible journey into what's happening to our hospitals. So this nurse midwife, she was riffed about a year before this happened. And the reason that she was riffed, as it turns out, was because the corporate vultures who bought this hospital, who took over this hospital, they decided to take back $260 million over the course of 3 years. They took this hospital and made what we affectionately refer to as a zombie hospital. There's no way that they could possibly function. So they were putting in rookie nurses in places where they had no business. They were cutting back the training. They were cutting back. Nobody did code drills on this code team. That code was ridiculous. And of course, what kind of anesthesiologists were they hiring? You know, the word kind of gets around when you have a story like that about a nurse who runs over somebody and then makes herself a Good Samaritan hero. But throughout this litigation and taking the depositions, it took chipping away little by little by little to get the nurses to open up about what was really going on, about how this nurse was a bully beyond recognition, how her antics that got her kicked off the floor at one time were so over the line that she would draw these complaints. A lot of times she would get complaints from 4 different flavors of clinician: a nurse, the pharmacist, another attending on the case. She was a monster. Asterisk, the lesson for people like this who they know they're going to get sued, if you're nasty to all those nurses, you've got it coming. It is going to come. It's going to come swiftly. So without even being able to get my hands on the verge complaints, little by little, taking one deposition after the other, and each nurse would give me just a little bit more, until at the end, you know, what I like to see the verge reports, I wanted to see those verge reports, those complaints, because I wanted to see how they re-credentialed this woman with 40 complaints. But I didn't get them, and I made a conscious decision not to take that up to the appellate division, because I have a woman who is desperately needing to get out of that institution and to survive. And every 6-month trip to the appellate division lowers those chances. So, how can you, if you want to attack on an expert versus expert basis, while it looked like, I mean, come on, we have the Virginia Apgar professor of pediatric anesthesia. I mean, people who were so well published, and they hit me with 6 experts, all of whom said, don't look at anything else other than AFE. It's an atypical AFE. The way to get victory, clear victory, to get them to put up what the case is worth before you're in front of a jury is to expose them. And our theme in this case was to expose these characters as being in a conspiracy, by the way, this woman is absolutely amazing. And she was the Virginia Apgar professor of anesthesiology, and they would have these med mal defense clowns come in and try to attack her opinion. It was kind of laughable, but until you're in front of a jury, what difference does it make? They've got defenses. One of the most effective tactics you can use in litigation is if you hang in there long enough and you can get your doctors and nurses to point fingers at each other. That's a winning strategy. And here, where you have someone who is so nasty, who is so condescending, you know, we really figured out, with the help of an expert that Pat helped us find, that the reason that nobody was questioning what was going on was because this anesthesiologist was such a bully, they were afraid to. Everybody was afraid of her. I think the other attendings were afraid of her too. I think the surgeon in this case was afraid of her. So, on this one simple issue about, could you see the monitor? Could you hear the monitor? Oh, and by the way, the monitor was missing. Nah, come on, monitors, come on, you're joking. No, the monitor was missing. It was never found until I found it. After they admitted that these things were all tracked, they had like the barcodes and everything else. Hey, listen, we don't know which monitor was used. That monitors change. They go from one OR to the next OR, from one hospital in our chain to the other hospital. Well, we'll get back to that in a second. The other thing that is so critical is, you know, you've got your theme. We'll come back to our theme. But staying visual in these cases is absolutely so important. And we stayed visual in a unique way here. We stayed visual with, you saw the OR flow chart, okay? Which, God, I didn't want to say this so early in the, do you know that flow chart, which I spent weeks on, Canvas or one of these AI programs, after I feed it in, probably would do it in 26 seconds. But that's another story. The missing chart. So, you know, we kind of knew what was going on here, but sometimes you do need an expert, and this was an expert that we thought was unassailable. I'd never taken, you know, a clinical engineer, a biomed person and brought her into a case, but their risk manager made such outrageous assertions about what a vital sign monitor could do and couldn't do. See, the other thing we didn't mention was they said 2 things. Number one, the vital sign monitor was missing. Number two, it was, before it went missing, somebody inadvertently turned it off. And when they turned it off, it dumped all the data. Well, that sounds like bullshit. Are you kidding me? So I brought in the head of Yale's biomed, and she was the one who was my guide through the jungle of OR number 2. And what we did was, first we got the manual, and then I got an identical vital sign monitor, and we destroyed the credibility of their risk manager, of several people who vouched, of their biomed department, who vouched for the fact that there's no data preserved and that there's no monitoring strips. This machine doesn't do monitoring strips. I said, oh my God, don't they know I've got this machine? And don't they know that you can't just make data go away, and that plaintiffs' lawyers, even country lawyers like me, know something about metadata and doing an audit. And that's one thing that they'll never forget in this case. Every time they thought that, hey, listen, we're just going to pull the wool over this lawyer's eyes. What does he know about vital sign monitors? I got that vital sign monitor, and I got Samantha, and one night before this mediation, I said, I've got to figure this out. I put the leads on myself. I started doing jumping jacks and doing all crazy things because I wanted to hear that alarm when I became tachycardic, okay? I wanted to hear it. And that was the first time I heard it. And the next time I heard it,
when you say everyone can hear,
listen to her.
In the room, would you want to hear
Wait,
the vital sign monitor?
it's not my objection. You can answer.
Everybody in the room has a responsibility, and they always like to hear, and sometimes they look up above the drape and look.
Why do they do that?
It depends on the doctors, but it is mainly my responsibility about the monitor. The monitor is audible to all and everyone.
Okay, so we like this dynamic. We like it, makes sense. And what we did was,
Well, do you recall that she had to go out and get the crash cart because she couldn't find it in the Pyxis cabinet?
Because she didn't know where to look. So she went outside to get it from the crash car outside the room. It was in Pyxis behind me.
well, that's Dr. Salerno's revenge. Dr. That's Dr. Zaklama's revenge for Salerno outing her. So that was her revenge. Came at a pretty bad time for the hospital. So bringing in the right experts where they don't expect you to bring an expert in is very important. And we were able to establish our overarching theme, MAD, that this case was about missing, altered, deleted, and destroyed records. And I don't know where I came up with this from, but it just seemed like, man, I was mad. This case made me mad. From the minute they delivered an incomplete chart to when they made the vital sign monitor go missing to, Pat, I don't know what slide it showed the OR, but there was a slide you saw that showed the OR. We did 2 OR inspections. And I went in there with Samantha Harold and one of my assistants, and we're all dressed up in our bunny suits, okay, we're doing this inspection. And while they're all setting it up, as a plaintiff's lawyer who we ask questions, I'm walking around and going, okay, I'm talking. They brought somebody up from pharmacy. I don't know why. I didn't ask for anybody from pharmacy. But if you're going to bring somebody up from pharmacy, you better believe I'm going to ask them some questions. And then, so I'm gathering all this data. And then operating room number 3 is right next to operating room number 2. So while we're teeing up operating room number 2, I go into operating room number 3 with Samantha. And I said, Samantha, take a look at this machine. And you know what? The one in we believe to a strong preponderance of the evidence that the vital sign monitor involved in this, they just moved it to operating room number 3. Clever, except we turned that one on, and it showed that even after it was turned off, that the data was preserved for about 2 weeks. So that's without the memory card in it, turned off. Their theories about making stuff missing were exposed. We demonstrated in so many instances where there were changes to the chart. You'd think there'd be some consequence to that. But where the director of anesthesia suggests, Dr. Zaklama, maybe you want to make sure your chart is complete. So anyway, what did we get here? Where are we going with this? So you know what an adverse inference is. An adverse inference is that where something is missing, and it's missing because of the actions or the negligence of a party to the case, the inference is that had the vital sign monitor been there, the evidence from that would have been damning. It would have been very harmful to the defense. So this is just really the start about getting the adverse inference. Because in this case, I wasn't satisfied with just getting an adverse inference. Because when they told me that the peer review, the RFA, was done one day, and then they changed that to another day 10 days later so that I wouldn't be able to get any of that data. And when they made a big mistake. Defense made a big mistake in this case because the defense allowed the risk manager, in the middle of my deposition to her, I said, look, I need to see your whole chart. You don't have a problem with that, do you? And before a defense lawyer could say, you can't do that. There's information in there that is totally inappropriate. She carried out the chart and dumped it on the table because the risk manager in this case had something to prove. She claimed that she had spent like 826 hours on this case. And she wanted to show everybody how much work she had to do. And she brought out that chart, and it was a treasure trove of the lies and deception that I would later expose. And by using the metadata from the record department, which showed exactly when, after this catastrophic event, the hospital went into circle the wagon in hyperdrive speed, and where they all casually said, yeah, you know, we looked at it the next day, and we, just nothing extraordinary. We all got to look at it, but we didn't take any action that night. And the metadata from records showed that within 2 hours after Estefania was admitted into the ICU, they were printing, they were texting, they were taking those records. They had them sent to 16 different people. You can't imagine. There were like 30 entries of what they were doing, and they all denied taking any action for a couple of days. The only action they took was to get it ready for peer review. So I made a decision. And that decision was, I was going to name the risk manager as a defendant in the case because she was committing spoliation. She was committing a tort against my client. And I made the motion, they fought it, and then you have the risk manager as a defendant in that case. Well, it certainly changes, can I have that water please, Pat? It certainly changes, right over there, on that, there, on the, point. Here, wait. Wait, I knew I would get to use this sometime. So this was kind of a radical move, right? To personally name the risk manager as a defendant. Little did I know that a mere 6 months later, there was a case by the Appellate Division in New Jersey named Dondero versus Yacoub and Hackensack University Medical Center. That's the same medical center that they took Estefania to after she was dropped on her head. That case involved kind of the similar kind of conduct about holding back records and hiding records and making records disappear and this and that. And one of my dear friends who was the plaintiff's attorney in that case, he exposed it and he went one step beyond what I did. Not only did he name the risk manager as a defendant in the case, he named everybody who participated in that conspiracy to make records disappear, including, hold on, defense counsel. And that was like, it was atomic. And the Appellate Division upheld that lower court's opinion. So now, when you have these extreme cases, oh, and by the way, this is trending, right? We're trending to, I guess maybe with the exception of like the Epstein file, we're trending towards full disclosure. So now in states like New York and California, people who participate in a conspiracy to withhold information or delay the production of information to the point where, you know, you've ruined my case. I've got a schedule. I can't get my experts in. You've hidden all this stuff that I need. It's an integral part of my case. You guys are now on the defense line. Do you know how fast that case settled after that? And that's going to be something that is going to be a big issue for defense counsel. And to be fair and even-handed, plaintiffs, I think, do it sometimes. Do we delay production of things sometimes? We try to do it strategically and not violate the court rules, but it's a two-way street. So if you're doing something really clever by withholding or changing or just, you know, using your control of records to cripple the other side's case, lawyers are now on the line. So I want to get through some more slides here. So the visual aspect of this case, it's so critical. I want MAD drilled into the jury's minds. Everything I can do, I want it drilled in, okay? And this is right from our inspection. Look at that, I circled where, that was a picture we took. That's the printer for the vital sign monitor. We went in on our inspection and they're like, well, he's not gonna know what to do. We printed from that one in the same vital sign monitor, deception. And, oh, Lorraine, she loves me, okay? And then we just went through all these instances where, you know, they're destroying records, and there was just so much of it that it was just, this should have been the Dondero case, except they settled it on me. This should have been the Dondero case. I'm not sure I would have had the stones to name the lawyer, but he was getting close. And I'll just tell you a quick story. When I came out of OR number 3, okay, and with basically, look at that machine, we're doing the next machine, next inspection on that machine, the defense counsel followed by the risk manager, so irate that the lawyer actually, in that picture, there's 2 lawyers in bunny suits, he actually got into my face. This is right on right outside the OR, and the director of security had to hold him back because he was going to try to hit me. This just totally destroyed their theory that all documents, all data was stripped. So anyway, look, we had great graphics in this case. And keeping that theme, I think Pat went through a lot of these. Missing evidence, oh my God. Do you know a Pyxis that a circulator can't access? Not a good look. We dropped the disruptive physician thing, it was too much, even though we had the president of the hospital acknowledge that she was on a disruptive physician rehabilitation plan, but they had no written records of it. So when every second counts, every move that you make as a plaintiff's lawyer, every time you dig that spade into the soil, knowing that you may have to dig meters before you hit it, that's what counts. Every step you take, every time you dig deeper than they ever expect, that's what wins these cases.
Since her cardiac arrest, Ms. Mesa's life has been a torment. Since the cardiac arrest, the wide vistas of potential of her life have shrunk to a hospital bed, to nursing assistance, to physical therapy, which is painful, and occasional visits from her family, and the joy of her life, her baby. And that's it. Things we take for granted will never be hers. Just finishing this hearing and leaving the room is a pleasure she'll never know. Having a meal, never know it. Speaking, never know it. Her child's wedding, should there be one, she won't know it. It's difficult to explain how locked into this neurologic prison she is. But there she is. She didn't ask for it. She had no expectation this would be an outcome from what should have been the happiest day of her life, the birth of her child. And instead, it has devastated her life and doomed her to this limited gray existence forever.
Dr. Peter Salgo, I was teaching a course at the Medical School of Columbia, and he was the CBS medical correspondent. And when he sees suffering, he can express it like a poet laureate. And he is one of the keys to success in these cases, over and above the battle of expert witnesses. We got justice for Estefania. It took a long time. It was really tough on the families. And for that, the family is very grateful. But I feel that the system needs to be fixed. It still hasn't been fixed. and Zaklama, as of 3 weeks ago, showed up in an ambulatory surgery center doing her anesthesia. She never was taken to task by the board. She is living proof that our system of credentialing and disciplining bad doctors is far from being fixed. Thank you very much.
We have a few minutes for questions if anybody has questions.
That was great. Thank you very much. Here's my question. You made a comment about, as a plaintiff attorney, that if the patient dies, you've already lost. So in the last 8 months, I've been in 3 trials, all on the plaintiff side, all patients died, all in favor of the plaintiff. It seems to me that if this patient actually passed away, you may have gotten the same outcome anyway. Explain to me why you were so hard and fast about death versus somebody. I get the emotional aspect of it for sure for a jury, but this case settled anyways. You never went in front of a jury, right?
Sure.
Right, so explain to me your thought process.
That might have been a bit of hyperbole, but I will tell you with clarity that number one, take a look at what your elements of damages are, okay? So for example, your conscious pain and suffering, which is, I always say that's the big number here. Your cost of medical care, you lose those. I mean, what do you keep? You keep the cost of replacing a mother to this child. You keep the bitterness of the event and its sequelae, but you lose a lot of the stuff that goes on the board. And to me, the most important thing that you lose is you lose the theme. We're fighting for Estefania. We're fighting to reunite her with her daughter, to give her the best quality of life that these institutions stripped her of. So kudos. It's probably much more difficult when your client's not alive. But I vastly prefer to have my client there at the finish line.
I do want to add one point to be clear, because we like to put the pieces of the puzzle together. We don't know with absolute certainty what caused Estefania's cardiac arrest. Our anesthesia expert, the Virginia Apgar professor, believes it was because she got a 15 cc bolus of anesthesia that was given all at once instead of in incremental, slower doses, and that flooded up her spinal fluid and ended up causing her to go into a respiratory and then cardiac arrest. We're not sure. We got to the point in this case where we said, you know, we're not sure, but look at what happened when she arrested. It was so egregious. All the delays, all of the mismanagement of the code, all of the fumbling with nobody doing intubation or compressions for so long. It was almost anticlimactic as to what caused the problem. And in the end, it didn't really matter, because Sam was able to get a settlement that will keep the family satisfied and keep her in care for as long as she's alive. He wants to know numbers, Sam.
I'm not allowed to speak of that in its entirety, but I will tell you that the hospital, talk about adventures. The mediator comes to me and he says, listen, Sam, I know what you're looking for in this case, but you know, there was a group of lawyers that went in to talk to him who were not part of this case. They were the bankruptcy lawyers for the hospital. And I trust this mediator implicitly. And he said, Sam, you better settle your case. So, you know, the $13 million that we got from the hospital was a pittance in my estimation. But 3 weeks later, the hospital filed for bankruptcy, never to reemerge. So it was a lot of bittersweet things in this case, and while it felt good to have Estefania in a place where her family can visit her, and she seems like she's doing better. She seems like it's a better vibe for her. Bittersweet, and I still don't know. I still haven't given up going up against Zaklama and the state medical board and going after this legislation called the Patient Safety Act, which really should stand for the Dangerous Doctor Protection Act.
Were there any repercussions from Hackensack for, it seems like, even if these patients don't go to litigation for whatever results in their anoxic injury, that they wind up in these long-term care facilities, and then they're neurologically compromised, and then they're sent to these facilities after something happens, they fall, they're dropped, and then, they have a poor baseline anyway, they get a scan. A brain bleed's not something that you miss even on a CT scan. So that she was put in the ambulance and then seized and declared herself is something that's a little surprising to me. I don't think it's uncommon, but in this situation you were chasing bigger fish. But was there any discussion about looking into what Hackensack had done?
He's referring to
Well, here's another theory that I want you to be aware of. I did not sue all those doctors. I didn't sue the obstetric surgeon. I didn't sue any of the other people in the room because I wanted my laser to be on the bad guy. If I brought Hackensack in for, it would be a trivial increment in harm. I'd be losing my focus. So I stayed away from them because you don't want to dilute more than you have to.
Thank you so much. That'll be our last question for this session.
Coming up next on Legal Nurse Podcast, we're going to hear from a person who has built her business from scratch in a difficult time and has utilized her skills in chart review to discover a field that suits her skills and her needs. My guest is Tori Palavoda. Tori is on the board of directors of the American Association of Legal Nurse Consultants and is an independent LNC in Florida. Tori, we've just finished recording your podcast. Tell our listener, what were some of the major topics that we covered?
Well, thank you, Pat. It was a great conversation, and I enjoyed being on your podcast today. Some of the things we discussed were some of the usual questions as far as how did you get your first case and how were you first introduced to the LNC world. We also discussed different types of roles that I've done as an LNC. We discussed the importance of networking. I tried to talk about how I've gotten a lot of work through networking and referrals, and that I feel that's probably the biggest marketing tool that anyone can do. We also had a conversation regarding when there's a downtime, when you might have a lull in your caseload. What did I do? What did I do to help build back up? What did I do to fill in the time? And then lastly, you asked me about what are the top few things that I felt would be most important to let an LNC know. And I discussed those, my top 3 choices that I think would help an LNC get prepared for this journey.
There is nothing like learning from experienced people. And that last question that Tori covered is one that you are not going to want to miss. So coming up next on Legal Nurse Podcast, you'll have an opportunity to hear from Tori Palavoda. Be there. Thanks. Thank you for being part of the Legal Nurse Podcast audience. I'm delighted that you've joined us for this episode. Be sure to go to legalnursebusiness.com and get your free reports, look around the website, pick up some tools that will be useful for you, in your legal nurse consulting practice. And be sure to join us for the next episode.